Now coming to section 129, financial statement. Because you have to prepare the financial statement. And 128 is equal to section 209 of the old act. In section 209 of the old act, we used to say you have to keep it at a particular place, etc., etc. So this is virtually the copy of section 209 with the change that you have increased the amount of the penalty, as I said before. Now coming to section 129. 129 is equal to section 210, that you have to prepare the financial statement. How to prepare? What considerations you have to keep in mind when you prepare the financial statement? 129 financial statement. What do you understand by the financial statement? As I said before, financial statement has been largely defined, widely defined. In the old act, we used to talk about the balance sheet and the P&L account. Today, we are talking about the financial statement. So, financial statement includes the balance sheet of the financial year, the balance sheet at the end of the financial year, the profit and loss account for the financial year, the fund flow statement for the financial year, and the statement of change in the equity, if any, and any annexure, any note which is forming part of this, is also known as the financial statement. Annexure. So therefore, take for example, suppose I have the wristwatch. Wristwatch is annexed with the, by which we can use it, chain. So therefore, this chain is the annexure to the wristwatch, to the watch, and therefore this becomes the annexure. So therefore, the financial statement are the 5 documents. Maybe the balance sheet at the end of the financial year, maybe the P&L account for the financial year, maybe the cash fund flow statement for the financial year, maybe the statement of the change in equity value, and any annexure, any note which is forming part of it is also the financial statement. So what you have to do? Section 129 says that the financial statement the company has to prepare. How you have to prepare? The company has to prepare the financial statement. 3 things are to be kept in mind. Number 1, when you prepare the financial statement, comply with the accounting standards. Number 1. Number 2, to show the true and fair view. If you do not show, if your financial statement does not show the true and fair view, we cannot say that you are keeping the financial statement or you have prepared them. We have Schedule 3 today in the new Act. So the financial statement should be prepared in the form and the shape as provided in Schedule 3. Then further the law says, every item in the financial statement should be as per the accounting standards. Not only you have to comply with the accounting standards, not only there is a compliance of the accounting standards, but every item that you show in the financial statement should be as per the accounting standards. So this is how you have to prepare the financial statement. Then further the law says what it has to say here. You are a banking company. You are the insurance company. You are the electricity company. Or you are a different company under some other act. Are you bound to comply with the same accounting standards that we have provided? Are you compliant? So therefore the law provides the exception. The law says that this section will not apply to the electricity company, to the generation and the distribution of the electricity, to the insurance company, and to the banking company, or to any other company under the law. What does it say? If suppose because of the Electricity Act, which regulates the electricity company, some of the transactions are not shown, then we cannot say that the accounts of the electricity company are not showing the true and fair view. Because ultimately the electricity company is regulated by their actor. If the act excludes some other information, and as a result you have excluded the information, exclusion of the information because the law says, and because you are guided by the particular law, and the law says that kindly exclude particular information, and you exclude that information, then can we say that you are not showing the true and fair view? No. We cannot say that you are not showing the true and fair view. Similarly, you are the banking company. You are regulated by the Banking Regulation Act 1949. And that act says that a particular information, particular piece of the information is to be excluded. Then the exclusion means that we are not showing the true and fair view? No. And third, if you are the insurance company, you are regulated by the Insurance Act, or you are regulated by the Insurance Regulatory and Development Authority Act. And as a result of this act, you have to exclude some information. Then can we say that you are not showing the true and fair view? No. So therefore, this is the law that you have to prepare as per Schedule 3. You have to prepare after complying of the accounting standards. You have to show the true and fair view. But when it comes to the electricity company, when it comes to the insurance company, and when it comes to the banking company, then the two things are provided. One, nothing of this section will apply, which means you are not to prepare their accounts as per Schedule 3 of the Companies Act 2013. So nothing of this section will apply. And number two, if as a result of the legal provisions which are applicable to them respectively, if you exclude some information and we do not show the true and fair view, it cannot be said that we are guilty of not showing. So this is an exception that you have provided in regard to the financial statement of these specified companies. Then further the law says that this financial statement the board has to keep before the annual general meeting. This financial statement the board has to keep before the annual general meeting. Then further, as I said before, that we have widely made the provision. Our provision little wider than the provision under the Companies Act 1956. Then further the law says, 129, the law says that these financial statements will be accompanied by the consolidated balance sheet, by the consolidated accounts. So these financial statements will be accompanied by the consolidated accounts if we have the subsidiary company, etc., etc. Similarly, the financial statement of the company will be accompanied by the statement, by the silent feature, some features of the statement of the subsidiary as well. So you have the financial statement of the company. This financial statement will be accompanied by the consolidated balance sheet or consolidated financial results. And further, this financial statement of the company should be accompanied by the statement of the subsidiary, extracts of the statement of the subsidiary. So this is all the financial statement we have to keep. Suppose we do not comply with the accounting standards. Applicable accounting standards we have to comply. But suppose we don't comply with the accounting standards, what you have to do then? Then section 129 says, if your financial statement does not comply with the accounting standards, then three things you do. In the financial statement, you indicate the fact that we have not complied with the accounting standards. We have not complied with the accounting standards. Why you have not complied? Give the reasons. And what is the financial effect? If you do not comply, give the financial result as well. So therefore, if you do not comply, when you prepare the financial statement, you do not comply with the accounting standards. Give the three things. The very fact that we have not complied, tell in the financial statement. What is the reason that we have not complied? Give the reason that we have not complied. What is the reason that we have not complied? And what is the financial impact of non-compliance? So given the financial statement, these three things. Then further the law says, can the government grant the exemption to any of the companies in public interest from any of the requirements of this section? Because you cannot apply the law uniformly. From company to companies, the things are changed. To apply the law uniformly becomes cumbersome, becomes difficult. So therefore the law has given the right to the central government, either the central government on its own or on the application of the specified companies. Because these are the specified companies, they feel that we are not to comply the accounting standards. Yeah, we cannot comply all the things as the requirement of a company is different. As the size of a company is different. As the nature of a company is different. So they can apply to the government. So either the government on its own or on the application made by the specified companies. The government can, by way of notification, the public interest. Public interest is the dominating feature. The government may, by notification, the public interest, exempt any class of companies from any of the provisions of this Act. And you can grant the exemptions unconditionally or conditionally subject to conditions. You can grant the exemption, all right, we grant the exemption, okay, unconditionally. Or we can grant the exemption subject to the condition that you have to comply with these conditions, subject to this, we are exempting you. So can the central government grant the exemption? Yes. So you can. Then coming to contravention part of it. The contravention part and the penalty is the same as we have seen in section 128. So whatever penalty we have seen in section 128, almost the same penalty is repeated in section 129 with no difference. So section 129 says, if the company contravenes any provision of this section, then the company contravenes, then the managing director or the whole-time director in charge of the finance or the chief executive officer or the chief financial officer and any person who is charged with the responsibility of complying with this section, they are liable of not less than 50,000, which can go up to 5 lakhs. Now remember here, now 3 things are there. What do you understand by chief executive officer? What do you understand by the chief financial officer? Reference about which was made in section 128 and reference of which is being made in section 129. Chief executive officer means any officer who has been so designated. Section 2 provides, section 2 of the new Act provides that the chief executive officer is the officer who has been so designated. Then who is the chief financial officer? Any person who has been so designated. Any person who has been so designated, he is known as the chief financial officer. Actually, what happens? Well, the person is liable. Because sometimes what happens? But these are the people who are liable under this section. But sometimes what they do, they just assign this job to a person. Okay, please, you comply with this section. You take care of compliance of this section. So therefore, they charge some person for the compliance of this section. And if this section is not complied, then that person will be liable. But there's a little difficulty in this section. It could have been better if the law could have been little better. What we say that these people are liable. Managing director, whole-time director in charge of finance, chief executive officer, chief financial officer, and any person charged by the board. It's not sufficient. The law could have been little better. Any person who is charged by the board, who is competent, reliable to do this job. It's not that you charge any person. Further, when you say that we have charged this person, then you must prove in the court of law, if the case goes to the court of law, that we have assigned this job to this person who is competent. Not only we have assigned, but he is competent, he is reliable, he is in a position to enforce. Correct? But these provisions are missing, which were there in the old Act. So therefore, these are the people liable. The fifth person is who has been charged by the board. So therefore, this is 129. The government has the power to exempt and this is the amount of the penalty. This is 129.